sometimes for advocates or RPRs is when to access the court protection. When is someone really objecting to the care arrangements made for them or where they live, and what's going on in their lives, and what it amounts to a real objection. So being able to look at that to see whether someone, it's a case that you as an advocate should take to the court, make the notice to the court, or are we just talking about some innocuous behaviour that is just repetitive for no apparent reason. But you could say that someone who's changes from in their placement to actually sitting there by the front door with a suitcase in their hand and wearing their overcoat on a regular basis might be objecting to where they live and want to leave. If their behaviour will be considered to be more challenging, their attitudes to staff and non-compliant, as we might say, is that amounting to an objection? And looking through a list that's provided by Justice Baker in his addendum to AJ will no doubt help an advocate decide. There's a very good list of indicators for you to look at as to whether what's happening amounts to an objection. I mean, a lady in a care home where people said she was objecting because says, I want to leave. When in reality, when you look through the file and talk to the staff more closely and even speak with her, is that why I want to leave means I don't want to be in this room with all these people anymore. I want to go back to my own room and be quiet. And in fact, when she returns to her own room, she is actually content and says thank you, and any objection goes away. It's what does people perceive by the word I want to go home? What do they actually mean? And it's not always I want to leave the premises and go and live somewhere else. And you only really find these things out by visiting somebody on a number of occasions and getting to know them a bit and to hear and look in the files to see what sort of occurrences trigger that behaviour. So it's not always rush straight off to the court of protection without looking at what it really means that someone's saying. However, if in doubt, it's best to make the application rather than let it go. Before you think about rushing off to the nearest solicitor and to the Court of Protection to challenge someone's authorisation, you might well consider looking at the circumstances someone's in, whether those circumstances are different than when the DOLS was put in place, and whether a review of that authorisation is necessary. So perhaps there are someone's needs have changed and they either need more restriction or more consideration about how they are enabled to do certain things, change from the way they've started. Then ask for the review first. It's much easier and quicker to ask for things to be done at this stage than it is to go to the court that have a very long waiting list anyway, and some things can be actually looked at, like the regaining of capacity. A lady who had sight problems cured by cataract operation and hearing problems cured by proper looking out of her ear wax, now is able to hear and see sufficiently to understand where she is and what her care arrangements are. She's not objecting to where she lives, but now can demonstrate capacity to people who need to know. Not always doctors are the best to do that when you're talking about care provision in a residential placement. Sometimes it needs a social work background to be able to assess someone's capacity better. So you can always look at those things. Do they all still hold true? Has the person regained capacity? Has their behaviour changed in such a way that the authorisation needs to be changed, and that means looking for a Part 8 review with the supervisory body. As an advocate, I'm always trying to find ways of not going to the court of protection. It's much quicker and easier to try and iron out these problems either with reviews or discussions, because there is a long waiting list for the court of protection, and a lot of things can be sorted out at source. But sometimes it is necessary. I had a lady who was in a care home. She consistently said to everybody she didn't wish to be there. There was a question over the mental capacity assessment not being done in her first language, but nevertheless, she was into that capacity. She had an authorization. The family felt it would be difficult for them to be the relevant person's representative because they had been responsible for placing her in care. They had also tried and worked very hard with social services to do everything they could to keep mother at home and looked after in a family environment, but things just hadn't worked out. It would be very difficult for them to challenge the decision of being where her mother was, because there was no realistic alternative at the time. Also, it was very difficult for them as a conflict of interest, so they had a paid RPR to make the challenge to the Court of Protection. And it wasn't anything to take away from the family, it was purely for this one exercise. It's not possible for local authorities to keep granting all standard authorisations year on year without it being ratified by the court when someone is consistently objecting to where they are and why they're there. So we took it to the notice, it went to the Court of Protection to make the decision. Once the decision was made, or once the case was actually in court, the RPR, as the advocate who was the RPR, could go a step back, allowing the family to be much more involved as the unpaid RPR again, who had been closely involved in the matter for years, but because the conflict of interest had disappeared. And the court had made a decision. The decision was that she was in the right place, in the best possible place they could make for her at the time, and they became the RPRs because the decision had been made. There was no conflict of interest left. Taking a case as an RPR to the Court of Protection isn't necessarily an onerous business, because all you really have to do is to find a solicitor who is experienced in mental capacity law, who works in the Court of Protection, and bring it to their attention. You're just bringing to attention the fact that an individual is challenging where she is. It's free access to the Court of Protection for an RPR, and there are no fees. It's non-means tested legal aid. So there's no money involved. And for the advocate or RPR, there is really very little form filling to be done, because the solicitor do all that for you. All you're doing maybe is to sign the legal aid form, which is, as you're going to get it anyway, that's not an onerous task. And they will do the rest, in my experience. They will do the rest. You may have to produce a couple of old reports to back it up, or point just the solicitors in the right direction as to who holds the forms and the address of the supervisory body and such like, but not a very onerous task, and neither would you necessarily have to go to court, actually into a courtroom at all. You can just say, there is no benefit to the individual of me being involved in the court procedure because I'm an RPR and I've only just met them and I don't have that much involvement with them. There's no benefit to the individual of me doing it. Will you please take over as a litigation friend, give it to the official solicitor, and that often happens. So you don't even have to be a litigation friend to take the case further than bringing it to the attention of the solicitor.